the very amendment which introduces union territory does not introduce the term union territory in the chapter which is under the heading of services under the union and the states. So there is no contemplation of a separate service for union territory. When the constitution framers, the parliament amends the constitution, introduces union territory for the first time by this very amendment, what it says, it doesn't say, it could have logically said it intended to introduce union territory to have a separate service. That precedent for services for the officers under the service of the union, governor for services under the state, and administrator for the purpose of services under the UT. The same amendment, 7th amendment, which introduces union territory, also now provides for administrator and does not include administrator in services, does not include union territory in services. Therefore, my Lord Justice Chandrachud, my Lord the Chief Justice of India, then my Lord said that you will have to read the entry contextually, whether it was ever intended to be given to union territory. And therefore, the word used in 239AA is insofar as the matter is applicable to union territories. Plural, I'll come to that. That's a separate limb of argument. Lord, kindly see. Unamended 239. Administration of Part C state of the first schedule. Lord, the title makes it clear that Part 14 under the heading of services would not apply because it applies to states. And earlier it used to apply to A and B states. This is for Part C. My learned friend made extra efforts to ensure that your lordships do not go through Balakrishnan report. Lord, Balakrishnan committee report is necessary for two reasons. Lord, Balakrishnan committee report became the basis of the 69th constitutional amendment which introduced 239AA. It is the basic foundation. That is number one. Number two, the then Home Minister, while introducing the 69th Amendment Bill, in more than one places say that this entire bill is structured based on the recommendation given by Balakrishnan Committee. Wherever word state is used, union territory is outstate, that part of the commission I am not relying on. That my Lord, the Chief Justice of India has taken care, my Lord, in the Constitution bench. It has to be decided contextually, but to give context to the word insofar as it is applicable to union territories. Lord, your Lordship would examine whether a particular matter, Constitution doesn't use the word entry, particular matter is applicable to union territories. It's not in singular, it's in plural. Can Lakshadweep do that? Can Dadra and Nagar Haveli do that? That is the context. Lord, with special context with regard to Delhi emerging from the Balakrishnan Committee report. That complete control for various reasons. Lord, there has to be a lieutenant governor who is informed by the officers. Lord, nobody said the bureaucracy should be pliable bureaucracy. Lord, I personally had a very serious objection, though it was lightly said, monogamy, that permanent monogamy. No, bureaucracy is not wedded to any party, any government. Bureaucracy is wedded to the Constitution of India. But suppose national capital is under a siege. You take an example. National capital is under a siege. One arterial road, my lord, linking one section of the country to the capital is blocked with permanent structure. And if the government of Delhi sends food, it is the responsibility of the bureaucrat to inform the LG that this is the capital cannot be under the siege. That is the control, my lord, which is envisaged under 69th Amendment. If during the COVID period, the number of tests are brought down, my lord, with a view to ensure that the figure is good. It would affect, my lord, the future course of action the country would take nationally. The health secretary will have to bring it to the notice of the LG. That you cannot do that. At a particular point of time, the test has to be rigorous testing so that we know the real problem, whether we are dealing with a rat or with a dinosaur, so that the national policy can be accordingly framed. If we show only 10 persons are affected with COVID, though there are 500, Lord, we may have a situation where all high commissioners and ambassadors are affected, and the world over the message will go that the government of India is doing nothing. It is the national shame. Look, therefore, I am not saying the bureaucracy should be loyal to the central government, but the central government must have a say who will be appointed and who will head which department. Then, as I have shown from the terms of business, he is bound by the transaction of business rules. He is reporting to the minister. He is taking orders from the minister. He is bound by the instructions of the minister. If there is any difference, it goes to the Council of Ministers. Council of Ministers is supreme. Collective responsibility, democratic functioning, everything is, my lord, I respectfully bow. But to say that once the officer comes under my jurisdiction, it's my decision what to deal with, what to deal with him, and what to tell him. That goes against the very spirit with which 239AA is introduced. The interpretative process, this dissection of Article 239AA 3A reveals that Parliament has the power to make laws related to capital territory of Delhi with respect to any matters enumerated in the state list and the concurrent list. At the same time, the Legislative Assembly of Delhi also has the power to make laws over all those subjects which appear in the concurrent list and all but 3 excluded subjects in the state list. No discussion on insofar.
This, according to, doesn't factor in insofar as is applicable at all. It's not called upon. Not called upon to decide. You can also, this is what I was sharing with my learned friend, I put it to you because otherwise if you are wrong, you can immediately respond to us. This issue can explain Chief Justice Deepak Mishra's judgment on the ground that the issue as to the applicability of a particular entry in the state or the concurrent list arises here before us now in relation to services. That issue did not arise before them. They were not dealing with any specific entry as to whether it applies to that particular case because they were not dealing with the applicability of a specific entry. Perhaps it did not arise, though my judgment specifically deals with it.
Okay.
But perhaps Chief Justice Deepak Mishra didn't deal with it because we are not dealing with whether fire services will arise or services will arise or land revenue will arise or whatever. So broadly, the learned Chief Justice said these 3 entries will not apply to the Delhi Legislative Assembly. You don't have power in respect of those 3 entries. Apart from that, you have power over everything.
There are 2 respectful submissions. Whatever your lordships are never wrong.
No, nothing of the sort.
No. First, in my respectful submission, any discussion or analysis of Article 239AA will necessarily remain incomplete without touching upon this phrase.
But with that, Solicitor, that you need not labor upon at all. It is, of course, it's a part, and we have to explain that. We are with you on that. There's no question about it.
In the Constitution bench, it remains incomplete. Number two.
Now we have to decide what
is why of the Mehta, what we are getting. Case, despite this, correct? And in that case, the bench had no occasion to consider. We can consider and we'll consider it. That is
now we have to deal with it squarely.
See, now 219. That is where the difficulty starts. Thus, it is evident from clause 3 of Article 239AA that Parliament has the power to make laws for the NCT of Delhi on any of the matters enumerated in the state list and the concurrent list, and at the same time, the Legislative Assembly of Delhi also has the legislative power with respect to matters enumerated in the state list and concurrent list, except matters with respect to entries which have been explicitly excluded.
Actually, Solicitor, let me formulate it like this. As a broad principle, the Parliament as well as as a broad principle, let me go step by step. Parliament as well as the state legislature, in the case of the Delhi Assembly, let me do it like this. Parliament in the case of the Delhi Legislative Assembly, in respect of GNCTD, Parliament has powers to legislate on the state list and the concurrent list. No difficulty about Parliament. The Delhi Legislative Assembly, too. The Delhi Legislative Assembly does not have the power to legislate in respect of entries 1, 2, and 18 and entries 64, 65, 66 insofar as they relate to 1 to 18. Positive statement about Parliament, exclusionary statement about the Delhi Legislative Assembly. Now, the third aspect. The Delhi Legislative Assembly has the legislative power to legislate in respect of all entries in the state list and in the concurrent list, insofar as those entries are applicable to union territories. That third aspect, according to you, is a limiting feature, which has not been noticed by the judgment of the majority in the NCTD case. So, no doubt about the fact that Parliament has the power to legislate entirely in respect of the state list and the concurrent list. No dispute about the fact that the Delhi Legislative Assembly has no legislative jurisdiction over entries 1 to 18, 64, 65, 66, insofar as they relate. But third, even in respect of other entries in the state list and concurrent list, other than 1, 2, and 18, the Delhi Legislative Assembly has the authority to legislate only insofar as those entries are applicable. Only insofar as they are applicable to union territories. Now, moot question. Does the legislative entry of services relate to the union territories?
Are they implied expression? The implied expression.
Are they applicable to union territories?
But only I bow only last.
Now there, Mr. Solicitor, we'll stretch your argument. Your argument is that you're not contending that the Delhi Legislative Assembly will not have legislative jurisdiction over services merely because entry 41 uses the expression state. Because that you're trying to bring it within the fold of my judgment. I also say that, well, merely because state includes union territories in 358 of the General Constitution Act, it doesn't mean that every item in the state or concurrent list which refers to state will also include union territories. Because if the moment you say that, then the words insofar as may be applicable will cease to have meaning, right? Isn't it? So now, according to you, if you look at part 14 of the Constitution, which was amended by the 7th Amendment to the Constitution, consciously a departure was made while amending the Constitution not to bring in union territories into part 14 of the Constitution. So now I think what you really need to focus on is,
Sir,
how do you tell us that you admit that services were never intended to be.
That is right.
I'll immediately do that. Only my worry. I bow. It's not my attempt to.
Second aspect, I think two things which you may focus on these two aspects. One, how you argue that the legislative control over services were never intended to be part of the legislative powers of the Delhi Legislative Assembly. Two, even if we concede your argument that legislative authority over services is vested exclusively in Parliament, what about the executive power of the Delhi government?
It is always co-terminus. If I don't have the
not necessarily. No, it's not. Not necessarily. That's the problem. That's an area which we will have, as Brother Nisma also said. Because even if Parliament has legislative control over certain areas, the executive control over those areas is still vested with the states.
Till a legislation is made by the parliament.
And the state here, union territory may vest in union territory, which in fact I'll show in law would mean LG.
But suppose a subject is exclusively entrusted to Parliament, right? By in list 1, list 3, there's no problem. Suppose a subject is entrusted exclusively to Parliament in list 1. Does the state exercise executive power? Can the state exercise executive power in respect of that subject? A, the state.
If the parliamentary law so delegates, for example, some transfer of property act, citizenship act, central law in list 1, but they say that will be enforced by the collectors of the district who are under the state.
And in the case of a union territory like Delhi,
LG, I'll show the GNCTD Act scheme. LG is the authority.